Look at me,
Yes.
sir. You're looking ahead. I want you to look at me.
Okay, sir, I'm a truck driver, but okay. I have to watch my surroundings, make sure nobody tear up my stuff. I got a lot of people just driving back and forth around here. Okay, but go on. I'm sorry. I'm working like you are.
Listen, I'll tell you what I'm going to do. Mr. Begg, I'm adjourning the pretrial. Defendant to appear in.
Now,
Mr.
what you say?
Counsel.
I'm sorry. Yes.
Okay, stay with me now. I need to see your face. I'm looking at the ceiling. There you go. Tell me your name, please.
Mark Counsel.
Did you guys talk about this, Mr. Begg?
Yes, at this time, we're unable to settle it. If we can just get a scheduling order with some discovery, that would be great.
You owe this amount, Mr. Counsel?
I don't know. I have no idea. Oh, that amount.
Look at me, please. Wait. Look at me, please.
I'm at work right now. Yeah, I'm at work, kind of watching my surroundings. I'm at work. I'm a truck driver. Yeah.
You're not driving, right?
No. I'm parked at the dock, but I gotta keep an eye on this light. Yeah, I'm sorry. Go on. I'll try and keep it out. Look in the mirror.
Are you driving?
No. Look, I'm sitting in the parking lot.
Well, then what's prohibiting you from looking at me? Just look at me.
Okay, yeah. I can't even see you, to be honest.
Mr. Counsel, listen to me. They think that you owe $4,269.87. Your answer to complaint is, I want to settle out of court. Sincerely, Mark Counsel. I'm just asking you, do you owe this debt?
No, I did. I know it wasn't that much. I don't know if they put.
How much was it?
Can't remember, sir.
Well, then how do you know it wasn't that amount? Listen to me very carefully. Mr. Counsel.
It wasn't that amount.
Mr. Counsel, I don't need you getting smart with me, Mr. Counsel. You're working like I am. Really? Counsel, I think you should just file your motion. You do what you want. I'll set it for pretrial in 2 weeks. I'll set for pretrial in 2 weeks at 8:30, defendant to appear in person. What date is that going to be? The 27th?
27th, Your Honor.
You have to be in person December 27th of 26 at 8:30 in the morning. If you don't show up, I'm going to default you. Have a good day. Thank you.
Thank you, Your Honor.
I'm not in the mood to hear this nonsense this morning. Granite Televalley versus Ronald Allen Bodges.
Plaintiff or defendant. Well, first of all, I'd like to say, it doesn't appear that the defendant is present and he has a non-attorney individual.
Timothy Holloman, not Robert Holloman. Who's here? Is Timothy Holloman here?
No, he's not. I'm Robert Holman, his father, acting on his behalf with I guess, permission with a power of attorney.
I can't let you appear, sir. I cannot let you represent him in the courtroom here. I can't.
I'm sorry, Your Honor. When I read through the power of attorney, it gave me those privileges.
Yeah, you don't have I'm sorry. I cannot allow a non-attorney to appear.
Okay.
Now, you might have the power, I'm sure you do, if you're telling me accurately, to go hire the lawyer on his behalf. But I cannot let either he has to appear or you have to appear. I'm not quite sure. It says the funds or property are exempt from garnishment by law. And then it says the writ was not properly addressed or is otherwise invalid because there's improper service to an incorrect address. Jennifer, I don't have any response from the plaintiff here.
Judge, let me look in the file. I was out of the office on Thursday and Friday, so if it came in,
You're going to have, I don't want to make people come back if this is invalid. I'll let you go hire a lawyer. Let me just put it to you that way, Mr. Hallman. I can give you a week or two adjournment and you can go get a lawyer.
Okay.
Where was this served at, Ms. Faze?
It was e-filed on Wednesday.
You're talking about your response. I'm talking about the writ. Did you file a response?
They did, Your Honor. They filed a response on the 8th on Wednesday. I was out of the office, so it didn't get attached.
Would you please bring that down?
I'm printing it now.
Okay. I'm going to go on to another case. I'm going to ask you two to stand by and let me take a quick look at that, please. LBNV versus Sandal Taylor, file number 2504738. Okay,
Yeah.
everybody's name, please.
I'm
Good morning, Your
Sandal
Honor.
Taylor. Go ahead.
Lynn Olivier, appearing on behalf of plaintiff.
All
I'm
right.
Sandal Taylor.
I didn't receive anything from you, ma'am.
I called yesterday. She said she received it on the 7th.
Judge, I'm printing that as well. It's a one-page document she filed. It's not.
And plaintiff filed its reply brief the next day on the 8th.
All
right. And we can adjourn this. Defendant said that she didn't get her
Now,
copy.
let me take a quick peek at those, okay? We're going to have to figure out a way to handle that better though, Jen. LVNV versus
Sorry, Judge,
I understand. We'll talk about it. LVNV versus Hancock, Brian T. Hancock, 2600624GC. The parties here on LVNV versus Hancock.
Your Honor, and which case are you calling, Your Honor?
LVNV versus Brian T. Hancock.
Okay, Your Honor, I have not had either party check in on that one, neither attorney.
I'm glad I was gone for a week. This is how things are going to start out today, huh? Okay, Jefferson Capital versus Joe Tostage, 2600218. Is anybody here on that? John, can you turn that thermostat down, please? Sure. Is anybody here today besides?
Your Honor, both, I'm here with defendant on Synchrony versus counsel.
Synchrony Bing versus Mark Counsel, 2601656. 2600001.
Garrett Levine for the plaintiff.
Okay, I need you to.
Okay.
There you go.
Good morning.
All right.
Your Honor, we did writ him out of Wayne County. I've not had the county log in yet.
I don't know what to tell you. Why don't you just do whatever else you got to do, Mr. Levine, and mute us, and when they come in, I'll call them, okay?
I have a 9:30 pretrial with you. I think it's with you. So
You can just check back in. Well, I don't want to keep the county waiting if they're putting them in front of the camera there.
I'll be ready for you.
So just mute us. Okay, thank you. Orbit Leasing versus Preston Rose, 2601249.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Is Preston Rose here?
Yes, I'm here, Preston Rose.
Your name?
Preston Rose.
Did you two talk, Mr.
We have, Your Honor. There's settlement discussions ongoing. At this point, I'm just requesting 60 days of discovery and time for motions if needed, but I'm pretty sure this is going to get resolved before then.
Give me 1 second here. All right, just give me 1 second. And Mr. Kuipers, it's Matt Kuipers. Kuipers, and your P number is 71348.
That's correct. And I'm filling in for the attorney of record, Jeremy Chisholm.
All right, I'm going to give you until September the 15th of 26 to conduct discovery. Witness lists are due on August the 15th. I'm putting down 1/2 hour for trial. You don't have to file a trial brief. If you choose to, it has to be filed and exchanged not later than 27 days before the trial date. All motions and responses, I don't want witness lists. I don't want that kind of thing, but anything that's a motion or response to a motion, I'll need a second copy marked judge's copy. We're going to give you a trial date. All motions for summary have to be filed and heard not later than 20 days before the trial date. Why don't you give me one, Jennifer, for the latter part of October?
October 20th at 10:30.
At 10:30, okay? So that'll be, I'll send out the pretrial order. And you should have that, I would think, by Thursday or Friday, okay? Anything else,
Thank you,
Mr.
Judge.
Kuipers?
Nothing on this matter, Your Honor. I do have a 9 o'clock for Capital One and Brandy Regan.
Okay, let me see if I can pull that out. Any questions, Mr. Rose? So if, I'm gonna let you conduct discovery. If you think they have documentation or any other item that will help prove that you don't owe all or part of this debt, then you can request it in writing from them. Okay, sir? So you have a couple months to do that. And I wish you well. I'd encourage the two of you to continue talking. It's okay? Any
Thank you.
questions, Mr. Rose?
No, sir.
All right, good luck. Thank you.
Your Honor, if I may, there was a Samsung device.
Samsung device, I need you to identify yourself. We have no clue who you are. SM5F9 is on the screen. Samsung SM5 or F9. You have to identify yourself. Samsung SM F9, you have to identify yourself. You have to start your video and tell us who you are.
Judge, I've tried taking them to a breakout room as well in order to identify them. I'm going to go ahead and remove them.
Thank you. LVNV versus Myron Covington. 2601895.
Yes, good morning, Your Honor.
Good morning, Your
name,
Honor.
Okay, Ms. Law, good morning. Your name?
Attorney Brittany Law, P83917, appearing on behalf of plaintiff.
And Mr. Covington, your name?
Myron Covington II, sir.
All right, did you two talk, Ms. Law?
We did, Your Honor, and we reached an agreement in this matter.
Good. Tell me what it is.
The defendant has agreed to pay a reduced balance of $2,400 over 24 months of $100 a month, and that will begin August 14th of this year and be due on the 14th of each month thereafter.
And is the total judgment amount going to be for $2,400 even if he doesn't pay? In other words, you get credit for any payments, but if, let's say he makes 4 payments, are you saying it's then going to be reduced to $2,000?
Correct. We did talk, if he misses a payment, it will go back to the original amount of $2,978.
And is this in the form of a consent judgment or conditional dismissal?
Consent judgment.
So, sir, do you understand what Ms. Law just told me?
Yes, Your Honor.
She tells me that you've agreed to pay $2,400 with the understanding you'll pay $100 per month. A judgment will enter in that amount commencing August 14th and the 14th of every month thereafter until paid in full. So long as you make those payments, the balance will remain $2,400 less any payments received. So if you pay them all, that's it. You'll be done in 2 years. If you miss a payment, then the judgment amount, they're going to file an affidavit of noncompliance, and the judgment amount will reflect the balance of $2,978 less any other payments that you made. Do you understand that?
Yes, Your Honor.
Do you agree to those terms?
Yes, Your Honor.
And does Ms. Law have your permission to sign your name to this proposed consent judgment?
Yes, Your Honor.
Any questions at all, Mr. Covington?
No, sir.
All right, you are all set. Thank you very much. Good luck.
Thank you.
Thank you.
All right, you too. Thanks.
Midland Credit versus Lynette Cloud, 2601416. John, they brought some paperwork here. I told them to put up here. Let me see what you just grabbed. That one you can take. Yeah. All right. Do I have anybody on Midland Credit versus Cloud?
No, Your Honor.
This is going to be called Chase a Lawyer Day again, huh? What was the other case that you didn't have anybody check in?
LBNB versus Hancock. It's an
Give
SD
'em-
motion.
Have somebody call them each. If nobody answers and nobody shows, I'm simply going to dismiss the case. Jeff, Stamson Billy Alohi versus Sucre Singh and Michigan Truck Driving School, Inc. 2601776R. Anybody here on that?
I don't have anyone on Zoom, Your Honor.
At what point am I going to just start dismissing cases? That's the question. Man, I don't understand this. Did I call Orbit Leasing versus Preston Rose yet? What happened with that? Nobody here again on that?
No, that was for the pretrial.
Oh, yeah. So that was, okay, my fault. All right. All right. This is SoFi Lending versus Timothy Hallman. 18R2629. John, you had that done.
Good morning. Again, Your Honor, Andrea Face for the plaintiff, P76952.
Okay. And Mr.
That should have been, and I think it's that one right there, the binder.
Oh, thank you. Mr. Hallman, your name?
Robert Holman.
I'm gonna have you take this. You're gonna have to get a lawyer. How long will it take you to get that for your son? Here you go.
At least a week.
I'll adjourn it. Let me give you 3 weeks. We'll adjourn this 3 weeks. And you can make sure you get a lawyer here. Oh, I'm not gonna be here that day, am I? Yeah, I am. Adjourn 3 weeks to what would that be? The 3rd?
Yes, Your Honor. I was going to ask you actually if we could add an afternoon that week. So could we do it at 1 o'clock on that Monday, the 3rd?
Yeah.
Okay.
What do I have in the morning? I can't do in the morning.
Probation and department reps.
August 3rd at 1 o'clock, we'll do this, okay? I'll have the motion heard, but you have to bring a lawyer, Mr. Coleman, okay?
Yeah, very good, Your Honor.
All right. Anything else that anybody needs to bring up before I set this aside?
I'm not from plaintiff, Your Honor. Thank you.
No, Your Honor.
All right. We'll see you guys on August the 3rd at 1 o'clock. Thank you very much. Have a great day.
You too.
You too.
All right. Is anybody here that has a case, right? Anybody where I don't have to call lawyers or have the staff call lawyers?
Your Honor, Mr. Kuipers is here on Brandy Reagan. They're ready.
We're ready.
Which one?
Capital One versus Reagan. 1617 is the case number.
Capital One versus Brandy Reagan, 2601617.
Good morning again, Your Honor. Matthew Kuipers on behalf of the plaintiff, P71348.
Ms. Reagan, you have to unmute and tell me your name, please.
My name is Brandy Regan.
Did you two talk and try to resolve this?
We did, Your Honor. Same situation. Settlement discussions are still ongoing. Plaintiff's just requesting 60 days discovery and time for motions, but I'm hoping this will get resolved before motion is filed.
Great. All right, so this is what I'm going to do, Ms. Reagan. I'm going to give you the same dates that I gave on the last one, and you can correct me if I'm wrong on any of these dates, Jennifer. September 15th will be the discovery cutoff. Witness list, I'm sorry, September 15th will be the discovery cutoff. There's no jury demand. There will be no settlement conference. Witness lists are due on August the 15th. You have to file a witness list, Ms. Reagan. You don't have to file a trial brief if you choose to. You have to file and exchange it not later than 20 days before the trial. I'm sorry, 7 days before the trial date. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Okay. Let's see. What did you give me again as a trial date on these, Jennifer? October
20th, correct,
at
10:30.
Perfect. So I will send these out. Ma'am, I want to know if you have any questions for me at all. Discovery is the exchange of information. If they have documentation that you think will show that you don't owe any of the debt or not as much of the debt as they claim, you can request those documents in writing. You could send them written questions called interrogatories if you so choose, okay?
Okay.
And I'd encourage you two to keep talking. Do you have any questions for me, ma'am?
Yeah, you said that I'd have to file a witness.
A witness list disclosing the names of all your witnesses by August the 15th.
Okay.
If you have witnesses, you might not have witnesses.
Okay, just myself.
Okay. But that's all I can say about that.
Okay.
If you have any other witnesses, you need to add them on that witness list too, okay?
Okay.
Anything else, Mr. Kuipers? Here you go.
No, that's it, Your Honor. Thank you.
You guys have a great day. Good luck to you, Ms. Reagan. CD.
Thank you.
Thank you. Capital. Oh.
Your Honor, on the LVNV versus Hancock, Miss Law is going to handle that one. I just have to get a call into Mr. Strauss's office now.
You guys didn't resolve this, Ms. Law? Why are lawyers not showing up?
I'm sorry, Your Honor. I'm trying to look into that. It wasn't on our calendar for today.
Well, it was on everybody's calendar for today. But what time did we have it scheduled, Jennifer? I just don't understand. If I got out here an hour and a half late, they'd be complaining about me. But lawyers showing up more and more late like this, it's just disturbing to me. It's like, how far are we going to go? How sloppy are we going to be?
Your Honor, we had it for 8:30 this morning.
Yeah,
Sorry, I
so
was
he's
leaving
not
Mr.
here and it's
Strauss a message.
9:25. I mean, if you want to hear your motion, ma'am, I'll be glad, Ms. Law, I'll be glad to hear it. I'm just not going to have us chase people around anymore. We're not babysitters over here. You want to argue it? Or I'll tell you what, you can call him. Tell him if he doesn't log in by 9:30, I'm hearing your motion. Okay, thanks. Christian Financial versus Austin Ortega. 2503014.
Good morning, Your Honor.
Good morning. Your appearance?
Elizabeth Butler, P80956 for plaintiff.
Where's Austin Ortega? Do you know?
He did
Your
not
Honor,
appear.
He didn't, did he send you the items?
only some of them, Your Honor, and I received them yesterday afternoon. I looked at them. Still do not have everything we need. We were here on June 29th, and you generously gave him until today just to send us the documents so we could cancel this hearing. And he emailed us that he does not intend to appear. He didn't give me everything. I would ask that the court consider a motion for bench warrant. He knows he's supposed to be here.
You know what? I usually require a show cause, but you know what? He was here. He didn't bring what he was supposed to bring. He was going to send it to you. He knew the hearing date. I agree with you. I'll issue a bench warrant. How much do you want? What is the amount of the judgment here again?
For today, it's $6,787.60.
Bench warrant to issue $2,000, okay? 2,000 cash. You can
Understood.
submit that. I'll make it 2,500. That's just not right. We ignored court orders. That's what I'll do. Thank you very much.
Thank you,
And for
Judge.
the
You and your
record-
clerk have a good day.
And for the record, I'm sorry, give me 1 second here. This was scheduled for
9
What-
o'clock, Your Honor.
9
Right.
o'clock?
Yes,
Yeah,
Your Honor.
9, now 9:27. Thank you. Have a good day.
Thank you. You too.
Samsung device, can I get your name, please, or I'm going to disconnect you? Judge, on the LV, or I'm sorry, Midland versus Cloud, I have left a message for plaintiff's counsel on that one as well.
Which one?
Midland Funding versus Lynette Cloud. No one appeared, neither party, and I did leave a message for plaintiff's counsel on that one as well.
What's happening? What's happening? Really, I guess I should just start dismissing cases. Maybe people will learn.
Your Honor, we have Teresa Roberts and Brookston escaping in the courtroom.
LVNV versus Teresa Roberts. 2601897.
Good morning, Your Honor. Attorney Brittany Law, P83917, appearing on behalf of plaintiff.
Ma'am, your name? Did we just adjourn this for another pretrial or something?
We did, Your Honor, but the defendant has paid this in full. We are sending in a stipulated dismissal this afternoon.
Okay, so you're dismissing the case with prejudice.
Correct.
Okay, is that, you understand that?
Yes.
And she has your permission to sign your name to this case, the stipulation that will dismiss the case with prejudice, meaning that they can't bring the action again arising out of this event transaction occurrence. You understand that?
They did send me a letter and then I sent it back, but they didn't get it in time to dismiss for today.
Okay, well,
Correct.
you're gonna send, you're gonna
We
send
just
it
got
in.
her signed one this morning.
I see. Okay, so send that over. I'll just make a note. Defendant was here. Plaintiff attorney here. Case dismissed with prejudice. I'll sign the order when it gets here. Have a good day. Do you have any questions, ma'am?
Thank you.
Good. You don't have to thank me. Good luck. Thanks,
you.
Ms. Law.
Thank
All
you, Your
right,
Honor.
so now I also have, I'm calling LVNV versus, Brian Hancock, 2600624. Ms. Law, did you call Mr. Strauss?
Yes, Your Honor. I haven't had a chance to reach his office, but we do have a consent judgment on this one.
Oh, well, that's different. You guys both signed it?
I have not received a signed copy back from him quite yet. It looks like we sent it 2 days ago.
Adjourned to July 27th. I'm sure we'll have it by then, right?
Yes,
We'll
we
adjourn
should.
this to July 27th at 8:30, and then I will go ahead and sign the order. Thank you very much. Do you have
Thank you, Your
another
Honor.
one?
That is all I have on my calendar.
Have a good day. Thank you. All
You
right.
too.
Now I'm gonna move on to Bingo. Where's that? That paper's all over the place here. LVNV versus Sandal Taylor, 2504738. Okay. Appearances, please.
Good morning again, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
And Ms. Taylor, your name, ma'am?
Sandal Taylor.
All right. So this is your motion. And you can go ahead and argue it.
This is plaintiff's motion for summary disposition. Your Honor, you should have in front of you both the answer to plaintiff's motion that defendant filed last week. And do you also have plaintiff's reply brief to her response?
Right.
Okay. So the last time we were here, we started plaintiff's motion for summary disposition. She admitted that she did have a credit card with Credit One Bank, which is the underlying credit card for this matter, Your Honor. You had ordered the defendant to file an answer to plaintiff's motion, and she did. And she lists 3 arguments. The first one is that she failed to include required disclosures. The plaintiff has failed to include required disclosures. Plaintiff does not know what disclosures she is talking about. She never articulated anything, so plaintiff is unable to respond to that, as plaintiff will not speculate as to what the defendant means. Secondly, defendant states that plaintiff used unlawful debt collection practices. Again, she doesn't articulate what she's means by that, and plaintiff will not speculate on that either.
I can speculate today. I can tell you what I mean today.
And for her final argument, she says that there's no.
Taylor. She's still talking.
I'm sorry, Your Honor.
I said she is still talking. Don't interrupt her.
Go right ahead.
Go ahead.
She, for her final argument, says there's no proof of ownership. That is incorrect. Plaintiff did provide the bills of sale. Defendant, however, is a non-party to the assignment, and she lacks standing to challenge the validity of the assignments. But plaintiff did show that each bill of sale is signed by the respective party to be charged, i.e. by an authorized representative of the entity that is transferring the accounts. And further, each bill of sale contains language to the effect that it is transferring, assigning, granting, or otherwise conveying accounts to the entity that is purchasing the accounts. And this type of language creates a valid assignment under Michigan law. Plaintiff therefore has valid proof that it is the owner of defendant's debt. Thus, defendant's final attempt to create an issue of fact in an attempt to evade liability for a debt that defendant does not deny incurring must fail. And plaintiff requests that its motion for summary disposition be granted at this time, and then judgment be entered for plaintiff and against defendant for the full amount paid.
Ms. Taylor, this is basically a letter. I adjourned it last time when you told me you didn't receive the motion. I gave you another opportunity. This is a letter. And it's not, I understand that you're representing yourself.
Correct.
But you still, there's still a smidgen of rules that you have to comply with. And you don't comply with anything here. There's no counter affidavit. There's no documentation that you have attached to anything here that creates a material issue of fact. I mean, there is no genuine issue as to any material fact. I'll let you say whatever you'd like to say for the record, but and you can feel free to tell me why I shouldn't enter judgment. But
Your Honor, the plaintiff has failed to give me original documentation that's signed. According to the Fair Debt Credit Practices Act, they are using misleading information to get money from defendants. They haven't given me anything stating that I have a signed original contract with the creditor. There's nothing. They have not given me that.
Anything else that
I
you
don't
want
have,
to say? Sorry.
I believe that they have not given me an original signed credit agreement. The original contract, they have not given me that, stating they can't prove to me that they own this debt, Your Honor.
Okay. Anything else, Ms. Olivia?
No, Your Honor, plaintiff rests on its pleadings.
Defendant has failed to raise. First of all, I have to take all the evidence in light most favorable to the non-moving party here, but even saying that with a letter basically that's 3 lines addressing the case, or I guess 4.5 lines, there's nothing that creates a genuine issue as to any material fact. The court finds there is no issue, no genuine issue as to any material fact, and will enter judgment in favor of the plaintiff. You have 90-80-04 in terms of the principal amount. What kind of motion fees and costs do you have?
Costs of $111.02 plus a statutory $20 attorney fee for a total judgment amount of $1,111.06.
You said 111.07, didn't you, in costs?
111.02.
111.02. And you're saying $20 statutory attorney fee. You said this to me last time. I don't know why they're only adding in 20 instead of 75, but they're entitled to 75. But if you want to limit it to 20 again, that's fine. That's 131.02. So do I have $1,111.02? Is that the total amount you're asking for?
6 cents. 1111.06.
Where's the other 4 cents come from? I thought you said 02 on the cost, 111.02.
The damages are $980.04.
You're right. My apologies. I thought it was, you're right. Thank you. So it's 1111.06. You submit your judgment, and I wish you well, ma'am. Good luck to you. Thank you.
Thank you. Have a good day, Your Honor.
You too. Thanks.
Thanks.
Tom Parisi versus Brooks Landscaping. Are we ready on that one, or do I have another quicker one here to go through?
Your Honor, this one will be quick. Mr. Parisi did not appear. Mr. Parisi contacted the court this morning, says he has no mode or means of transportation to the courthouse, so therefore he could not get here. He was requesting an adjournment. I told them that that would be up to the court on whether or not it would be adjourned.
He
He
only
has
lives
had the
in
date for 30
Brownstown,
days.
right?
Yes.
I mean, like,
He says he's disabled and cannot get here, but he doesn't have the ability to Zoom either, because I did ask that question.
your name?
Daniel Brooks.
I mean, he had to figure out a way. How do you get here and get the paperwork filed, you know?
He mailed it in, Your Honor.
Well, you had to figure out between that time, which was back in June, the early first week of June,
Yeah,
and now.
yeah, he had about 30 days.
I mean, if he can't use Zoom and he can't get here, I don't know what I can do for him. I'm sorry, he can file a motion to set aside the dismissal, and I feel bad, but, you know, he got to show up somehow. He could have, I don't know how badly disabled. I feel badly for him, but he's either got to learn how to Zoom or get here. I'm going to dismiss the case. You're all set. Thank you.
Thank you.
How about Samson Billy Alohi versus Sakral Singh in Michigan Truck Driving School, Inc., 2601776.
Your Honor, Mr. Alohi was the Samsung that we could not get connection with. He called the court. He's on his way here, but the defendants have not checked in with me.
Were they served properly?
This was a removal from small claims to general civil. And I believe it was removed by the defendants.
Well, but I'm going to end up giving them a judgment if they don't show up. I'm going to give the plaintiff a judgment. Rogers is not checked in, right? Do I have Midland Credit versus Cloud? Lynette Cloud, 2601416. Is anybody here on that one?
No, Your Honor, I left a message with plaintiff. Oh, I'm sorry.
My name is Philippe Cicchini. I'm here on behalf of Midland Credit, but I'm here for Lisa Robertson and Ladero Garner. I don't have I don't have the notice to appear for the one that you're calling right now, but I'm here. So if the defendant's here, I'd be happy to speak with he or she in a breakout room if that's allowable, but.
What was this up for, Jen?
Your Honor, I'm pulling it back up. It just says hearing.
It was a hearing regarding
Was this regarding the alternate service request?
Service.
Because they were requesting non-tacking.
Yeah, I require 3 things, and one of which is tacking. Mr. Cicchini.
Yes, sir.
So that was a problem. That's why I set it for hearing. I'm not going to just let you mail by first class and certified mail. You're also going to have to tag. So I've been doing that for decades.
I understand, Your Honor. This is the first I'm hearing about this case this morning. Like I said, I'm here to appear for 2 other ones. So if someone can provide me the case number, meanwhile,
it's 2601416. 2601416.
Okay.
So you can look that up. Are you here on Garner?
Yes, sir.
Midland Credit versus Ladero K. Garner. 2600458.
Morning, Your Honor. Philippe Cicchini on behalf of the plaintiff Midland Credit.
Mr. Garner, good morning, sir. Your name?
Good morning, Your Honor. My name is Ladero Garner.
Good morning to you. Did you 2 talk, Mr. Cicchini?
Yes, we did, Your Honor.
Any resolution?
Not today, Your Honor, unfortunately.
All right. I'm going to do the same thing on this one. September 15 is discovery cutoff. September 15 is discovery cutoff.
Okay.
And you have 1 L there or 2. It looks like 2 L's in your name, right, sir?
Are you speaking with me, Your Honor, sir?
Yes.
So Philippe, Philippe. So 1 L in my first name, if that's what you're referring to.
My eyes are going on me, among other things. And that's 69928, right?
Yes, sir. 69928.
All right. So, Mr. Garner, do you owe this debt, sir?
No.
Okay. I'm going to give everybody discovery until September 15th. There will be no jury trial. Nobody made a jury demand. Witness list due August the 15th. No settlement conference.
I didn't see theft.
I'm sorry?
I didn't see theft. Good morning, Your Honor. My name is Ladero Garner. I respectfully dispute the plaintiff's claim. I believe this account is
So, sir, what I'm going to do is I'm going to give you court dates and cutoff dates. You have to file a witness list disclosing the names of all your witnesses by August 15th. You have to file a discovery cutoff, which is the exchange of information. If you think they have something that you think will aid in your defense of the case, you can make a written request for it. If you want to send them written questions, interrogatories, you can do that. I'm giving you guys until September 15th to conduct discovery. I'm giving you guys until August 15th to file your witness list. We're going to set a trial date on October the 20th at 10:30 a.m. You do not have to file a trial brief, but if you choose to file one, it has to be filed and exchanged, not later than 7 days before the trial date, and all motions for summary disposition have to be filed and heard, not later than 20 days before the trial date, okay?
okay.
Do you have any questions for me, sir?
No, I don't.
I wish you well, sir. Good luck. Anything else, Mr. Cicchini?
Not on this one, Your Honor.
Have a great day. Thank you. There you go. Sadie. All right, Jefferson Capital versus Cassie Harbison, 2601006.
Good morning, Your Honor. Mimi Kalish. My P number is 52383 on behalf of the plaintiff.
Good morning, Ms. Kalish. Ms. Harbison, can you tell me your name, please?
It's Cassie Harbison.
Okay. This is simply a pre-trial, right?
It's a date and time for a motion for summary disposition, Your Honor. Let me make sure of that. Yes, it is.
I don't think I have that, Jennifer. Did you file a response, Ms. Harbison?
No, not this last time. I only did the first court date. I don't think I understood that I was supposed to.
Do you agree that you owe this debt?
Yeah, I never said I didn't. Yeah, I do.
Okay. So you can just give me a little bit of background here, Ms. Kalish, and I'll be happy to.
Sure, Your Honor. This case originated with Comenity Bank. It was a K Jewelers credit card account. The amount in dispute is $2,472.32 plus court costs and a statutory attorney fee. It's brought under MCR 2.116, C9 and/or C10. It's plaintiff's position that Ms. Harbison has not put forth a valid defense, nor are there any material facts at issue for the court to decide. We're asking the court to make a decision as a matter of law and to enter a judgment accordingly. As I said, the principal balance is 247232. Court costs are in the amount of $151.48.
And does that include your statutory attorney fee?
It does not. I'm not seeing the statutory attorney fee, and sometimes that's in accordance with the client guideline. It doesn't appear that this Jefferson Capital allows for the statutory attorney fee. I am getting a total proposed judgment in the amount of $2,623.80. And if the court needs me to break down the court costs, I can do that.
No, I don't. Ma'am, do you have anything you want to say? You agree that you owe that amount?
Yeah.
Court is going to find there's no genuine issue as to any material fact. Judgment will enter in favor of the plaintiff and against defendant. 2,623.80 is the total amount, and you can submit your judgment. And I hope you'll work out a payment arrangement with them, Ms. Harbison, so they're not garnishing wages and everything.
Yep.
Good luck to you both. Thank you very much. Have a great day.
Thank you,
have another one in
Judge.
front of me by chance, Ms. Kalish?
I don't have any more today. Thank you, Your
All right.
Honor.
Have a good day. Thanks.
You too. Thanks.
Good luck, Ms. Harbison.
Thank you.
Midland Credit versus Lisa Robertson, 2601444.
Good morning, Your Honor. Philippe Cicchini again on behalf of Midland Credit.
Your name, ma'am?
Lisa Robertson.
Any resolution on this one, Mr. Cicchini?
Yes, Your Honor. The defendant and I had an opportunity to speak in the breakout room this morning, and we have reached a resolution for this one. If you'd like, we can put it on the record. The defendant has agreed to pay the debt owed of $1,267.34. She has agreed to make payments of $25 per month beginning on August 1st, to be revisited in 1 year to see if the payments can be augmented. And the defendant has given me permission to sign on her behalf, Your Honor.
It's in the form of a consent judgment, true?
Yes, Your Honor. I apologize. Yes, in the form of a consent judgment.
Do you agree to those terms?
Yes, sir.
So you agree that you owe $1,267.34, and you are agreeing to pay these at the rate of $25 per month beginning August 1st of 26, correct?
Yes, sir.
And also with the understanding that that installment payment order, you got it worded, counsel, correct me if I'm wrong, that the installment payment order may be reviewed on motion of either party on or after August 1st of 27. Is that correct?
Correct, Your Honor.
You do?
Yes.
Okay, perfect. Any questions, ma'am?
No, sir.
And does Mr. Cecchini have your permission to sign your name again to that proposed consent judgment?
Yes, sir.
All right, you are all set. I sincerely wish you well. Good luck. Thank you very much. Have a good day.
You too, sir. Thank you.
Thanks. Jasmine Owens, have a good day, Counselor. Or do you have another one?
Your Honor, I guess I'm just trying to get information from my paralegals regarding the cloud case. I just have an update on the information we received from the process server. So I don't know if you'd like to recall that one. I'm looking at it right now in real time. I'd be reading to you as the first time I'm seeing it. So if you give me a moment, if you want to call a case and come back
Take
to me,
your time. Take your time. I'll go on to another case. Jasmine Owens versus Fountain West, 2601734R. Anybody here for Fountain West, Jen?
Yes, Your Honor. Mr. Levine is here as well as a representative from Fountain West.
Okay, Mr. Levine, you're representing Fountain West, correct?
Correct.
Your name, ma'am?
Jazz.
All right. So this is just a pretrial. Did you two talk?
Yeah.
No.
I'm going to go ahead and set it for discovery cutoff dates and witness list due dates and that type of thing. Okay, ma'am? So here's what I'm going to do. And you can feel free to talk to Mr. Levine at any time about the case and see if you can resolve it. Discovery is permitted. It's to be completed by September the 15th of 26. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury trial. You do have to file a witness list disclosing the names of all your witnesses by August the 15th. I'm putting down a 1/2 hour for trial. There will be no settlement conference date. You do not have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. The trial date will be on October the 20th of 26, and that'll be at 10:30 a.m. Do you have any questions? You understand what I mean by discovery? If they have documentation that you think you would like that will bolster or help your case, you can request it in writing.
I'm thinking that I was going to do that today, but I have to wait.
Well, this is just a pretrial. And you have the right to conduct discovery now. What I'm doing is for 60 days. So you guys can exchange information. And if they have an objection, they'll tell you. But I'd suggest you call Mr. Levine. You're saying that the apartment was in an unsanitary and
Can a judge trust someone who's already tested positive for drugs while out on bond? That difficult question became the focus of this courtroom hearing. The defendant had previously appeared before the judge and failed a drug test. Rather than sending him straight to jail, the judge gave him another opportunity. He ordered the defendant to wear a drug monitoring patch, a device designed to continuously monitor drug use while awaiting trial. When the defendant returned to court, the judge asked one simple question: "Did you get the drug patch?" The answer wasn't what the court expected. The defendant admitted that although the patch had been applied, it still hadn't been tested. That response immediately concerned the judge because one of the most important bond conditions still hadn't been completed. Instead of making a quick decision, the judge wanted answers. She ordered the defendant to sit in the jury box while court staff arranged another drug test that very morning. It was clear she wasn't willing to rely on assumptions or incomplete information. Before deciding whether the defendant had violated bond conditions, she wanted fresh evidence. The hearing showed how carefully judges often balance accountability with fairness. Rather than punishing first and asking questions later, she insisted on verifying the facts before taking further action. That approach protected both the integrity of the court and the defendant's legal rights. The courtroom then shifted to another case involving a woman charged with aggravated assault with a deadly weapon. Can a judge trust someone who's already tested positive for drugs while out on bond? That difficult question became the focus of this courtroom hearing. The defendant had previously appeared before the judge and failed a drug test. Rather than sending him straight to jail, the judge gave him another opportunity. He ordered the defendant to wear a drug monitoring patch, a device designed to continuously monitor drug use while awaiting trial. When the defendant returned to court, the judge asked one simple question: "Did you get the drug patch?" The answer wasn't what the court expected. The defendant admitted that although the patch had been applied, it still hadn't been tested. That response immediately concerned the judge because one of the most important bond conditions still hadn't been completed. Instead of making a quick decision, the judge wanted answers. She ordered the defendant to sit in the jury box while court staff arranged another drug test that very morning. It was clear she wasn't willing to rely on assumptions or incomplete information. Before deciding whether the defendant had violated bond conditions, she wanted fresh evidence. The hearing showed how carefully judges often balance accountability with fairness. Rather than punishing first and asking questions later, she insisted on verifying the facts before taking further action. That approach protected both the integrity of the court and the defendant's legal rights. The courtroom then shifted to another case involving a woman charged with aggravated assault with a deadly weapon. Her attorney filed a motion asking the judge to modify one specific bond condition that prohibited her from driving. The defense explained that the restriction made everyday life nearly impossible. She needed transportation to get to work, take her youngest child to school, and attend court-ordered mental health appointments. Prosecutors acknowledged that the original driving restriction existed because the alleged assault involved a vehicle, not because the defendant had been intoxicated. After reviewing her employment,